Today we're with David Shapiro. David Shapiro is a criminal defense attorney located in San Diego, California. He's agreed to answer some online questions for us that were posted. Today's questions are specifically related to theft and theft offenses. If you, first of all, if you're one of the people who actually posted these questions, you're going to get your answer right away. If you personally have been charged with a theft-related offense or crime, obviously feel free to reach out to David. But in addition to that, he's agreed to post or answer questions online. And the way you're going to do that is simply post your question at the bottom of the YouTube video. Those will get emailed to him, and he's going to get back with you with any responses. With that said, let's go ahead and get started. And David will answer or ask your first question here. I was caught shoplifting, and it's on video. Is it still possible to defend me?
Well, a couple of things there. The first is, if it's on video or not, it's always possible to defend you, no matter what. Obviously, you're entitled to representation, and no matter how bad or no matter how good a case may look, particularly as it relates to theft offenses being on video, it's always possible to defend you. And what you need to understand is that so many cases, the large majority of cases, are ultimately resolved short of taking the case to trial. Meaning, just because you may be on video doesn't necessarily mean that there's nothing that can be done. From a trial perspective, it will be up to the prosecution to prove, at least in California as it relates to theft, intent. Now, there's a lot of people who may take stuff or walk out of a room with a piece of property that may not be theirs that they may forget about. But it's up to the prosecution to prove intent. Now, how do they prove intent? Even if the video shows you putting a piece of clothes over your arm and walking out without paying for it. Well, they prove intent two ways: by direct evidence, by way of a video where you may have a video confession, yeah, I knew what I did was wrong, or they infer it circumstantially by way of saying, hey, there's no way in the world this person, we could assume their intent, because there's no way in the world they would have done this if they did not have the intent to steal. But even if there's a video, doesn't necessarily mean there's no defense to the case. And if there is a video, or like I said, even if there's not, you know, there's so many things you could do, particularly with theft offenses, to try and make things as right as possible, as quickly as possible, even if it is not a good case for trial, to deal with the issues that you may have that got you in the situation to begin with, and present you to the prosecution in an effective manner by way of mitigation documents, proactive things that I could tell you to do that'll distinguish you from everybody else who might be in your position charged with that offense in that courtroom, in that day, with that prosecutor. And that's a lot of what my firm does on a day-to-day basis.
Okay, well, that makes a lot of sense. The next question, this is very specific. I'm being charged with forging some checks. The total value of those checks was $2,700. I have no prior convictions. Am I going to get a felony?
You're going to get a felony. You're probably going to be charged with the felony. Whether or not the case resolves for a felony, you know, will be up to a lot of things. It'll be up to the state of the evidence. It'll be up to the courtroom and the courthouse where your case will be heard. And to some degree, it'll be up to the criminal defense attorney that's either assigned to your case or that you hire. That amount, $2,700, forged checks, you know, you're looking at forgery charges. Even if the amounts of the checks were under $950, they could cumulatively get over that amount, and you would be charged possibly with one count of forgery. You could also be charged with commercial burglary as it relates to any establishments you may have entered with the intent to commit that theft offense or the forgery offense inside. So, you know, can you be charged with a felony? Yes. Can it be multiple felonies? Yes. Would the case actually resolve for a felony, or would it make sense that the case would resolve with you or wind up with you being convicted of a felony? A lot of that depends on the facts of the case. A lot of it depends on what, if any, prior criminal history you have, your ability to make restitution to the aggrieved party, in this case the alleged victim, would be important as well. You know, and how the case is presented and what things you do between the date of the offense and the date when the case gets before a judge and before a prosecutor, with the advice of your attorney. All those things could factor into it. Not necessarily saying there's a hard line in the sand that $2,700 means yes or no, but you know, there's a lot of things you could do to try to minimize the damage done, even if you're charged with felonies for forgery.
Okay, all right. Next question was, I have been falsely accused of stealing from my girlfriend's house, but it was my computer that she gave me as a gift. Do I still need an attorney?
Wow. Okay, there's a couple of things going on here. Based on your question, if I understand it correctly, it seems like you were at your girlfriend's house. She gave you a computer. You left with that computer. Now someone, girlfriend or girlfriend's family, are saying that you took it. Yeah, you definitely need an attorney, even if charges haven't been filed yet, because what you don't want to have happen is you make any statements that can be used against you to the girlfriend's parents, and certainly to law enforcement, assuming the girlfriend and or the girlfriend's parents have filed a police report or a claim, and then you're contacted by a detective. The last thing you want to do is say anything without first speaking to a criminal defense attorney who knows what they're doing. And I say who knows what they're doing because there's a lot of criminal defense attorneys in San Diego or anywhere for that matter that don't. Okay, my general rule of thumb as it relates to speaking to anyone about anything when you're accused of a crime, in this case a theft offense, would be less is more. Meaning that in order to put this on you, so to speak, even if you did take your girlfriend's computer, whether it's yours or not, aside from the fact there's a claim of right defense, an affirmative defense to theft, my whole thing is, why even confirm or corroborate that you were even at the house, that this person is even your girlfriend? Why give them A, B, C, and D when they only need to get to E in order to convict you? So if you don't say anything, it doesn't necessarily mean you're guilty. The cop may not be happy about it, but what you're doing is protecting your rights to not build a case against yourself and to not do law enforcement's job for them. So, you know, can you? Yes. Can that happen? Yes. Should you need to hire an attorney? At the very least, you should consult with an attorney who could possibly get in there and be your voice to the girlfriend's family, law enforcement, the prosecutor's office, whoever, whatever. If I say something on your behalf, it cannot be used against you the same way you could.
Okay.
You could.
Makes sense. The last question we have is, does 3 strikes apply to petty theft?
No. 3 strikes law in California has been around for a considerable amount of time, a couple of decades now at this point, and for a while you could have 2 prior strikes. Now, I guess the first thing I should do is define what a strike is. A strike in California is a serious and or a violent felony. That isn't necessarily what you or I or anyone else might think is our version of serious or our version of violent. It's what's the law delineates, or basically what the law states is a serious or a violent felony. They list them out over the course of time. So what happens is, the first thing is you need to have a serious or violent felony. For a period of time, the third felony, if you have 2 prior strikes, could result in a 25 to life sentence. The law changed a short while ago that said the third case on these 25 to life cases now need to be a serious or a violent felony themselves, not just any felony, because far too many people throughout the course of the last 10, 15, 20 years were being sent to prison for a petty theft offense, what normally would be a misdemeanor. They're being sent to prison for the rest of their life, or 25 to life, which mostly means life here in California, because they have 2 prior strikes. In November of 2014, California voters passed something known as Prop 47. Proposition 47 makes most, if not all, petty theft offenses misdemeanors, unless you have certain prior criminal history that basically says you don't qualify for that. Petty thefts, no matter how bad your record is, 95 out of 100 times can only be misdemeanors. So you're certainly exempt from the 3 strikes law previously. As of November of 2014, you should be exempt from even a felony, let alone a serious or a violent felony, and it is a 6-month maximum misdemeanor unless there's certain conditions that would bump it up to a felony.
Okay. All right. Well, Dave, thanks for your time. Like I said to people watching, if you have any questions, you can reach out to David directly. You can visit his website. And you can also post those questions at the bottom of the YouTube video. And thank you for your time again, Dave.
You got it, Ryan. My pleasure.